Vanessa, and good morning and welcome. My name is Scott Skinner-Thompson. I'm a professor here at Colorado Law, and it's my honor to welcome you to this year's annual Silicon Flatirons Privacy Conference, this year focused on the role of surveillance in subordinating different members of marginalized groups and the role of privacy as a potential legal tool of anti-subordination. Before going further, I would like to start by acknowledging that for many of us in North America, we are meeting on the lands of First Nations and Native Americans peoples. In Boulder, Colorado, the land is the traditional territory of the Cheyenne, Arapaho, and Ute nations, and I'd like to pay particular respects to these communities. I also want to emphasize that at Colorado Law and at Silicon Flatirons, we put a priority on our shared humanity. As such, we recognize that our speakers and anyone else on or off screen may be in space with roommates, partners, children's, pets, or other things happening around you. And of course, such interruptions are to be embraced rather than to be a source of embarrassment should they arise. So thank you for all of you for your patience and understanding. At the outset, I also want to thank the simply tremendous information technology professionals here at Colorado Law who make not just conferences like this possible, but the entire law school function, particularly during the pandemic. I feel very confident when I say that they are some of the best professionals and best people around. In particular, thank you to John Sabray, Teresa Coverly, and Lionel Wynn, among others. Deepest thanks as well to the incredible Silicon Flatirons team, including Nate Mariotti and Vanessa Kopel for getting this event organized and herding all the cats. This event it couldn't happen without their efficient organization. Thank you so much to the Silicon Flatirons Executive Director, Amy Stepanovich, and Privacy Initiative Director, Professor Margot Kaminsky, whose scholarship and/or activism in this area is pivotal and who so graciously provided this platform to talk about these issues, including my book that shares the conference title, Privacy at the Margins. Penultimately, thank you to the absolutely inspiring and brilliant group of scholars and advocates joining us today. I couldn't be more thrilled by the folks who have accepted our invitation. It's really the people at the forefront of thinking about privacy and marginalization, and you're all in for a real treat. And finally, thank you to you for taking time out of your busy and hectic schedules to join us in conversation about the role of privacy in advancing anti-subordination. I have just a couple of opening substantive thoughts that hopefully contribute to some of today's discussion. Of late, as you may be aware, the right to privacy has been getting more societal and regulatory attention, as evidenced by the uptick in state and potentially federal legislative efforts to regulate data privacy. And social norms seem to be seem to be shifting in favor of a more meaningful right to privacy in many contexts as well. In my view, that's a good thing. But for many members of different marginalized communities, the important role that the lack of privacy plays in their lives has long been recognized. Indeed, it's long been felt. For communities of color, Black, brown, and immigrant populations, Muslim populations, disproportionate state surveillance isn't some new phenomena, but a defining condition of their lives. As put by sociologist Simone Brown in her tremendous book, Dark Matters, which focuses on racialized surveillance, surveillance is nothing new to Black folks. It is the fact of anti-Blackness. And that surveillance in its carceral, administrative, technical, and privatized forms hasn't just eroded people of color's dignitary or autonomy interest in keeping information secret, but has served as a gateway, but for cause, through which state violence has been inflicted. Make no mistake, of course, structural and individual prejudice are the principal causes, but privacy serves an important tool or facilitating role in that subjugation. For queer folk too, surveillance hasn't just forced people out of the public square and into the closet at times, it has cost queer people, particularly trans women of color, their lives. For women, privacy violations and public shaming is not just an embarrassment, but represents the use of surveillance to control and subvert women's sexual identities and freedom. For people who are economically and housing insecure, the lack of privacy in public forces them to live their entire lives under state and social gazes. If an act is banned in public space, for the homeless, it amounts to a total and complete ban because they have no private space in which to perform the action. So privacy for the homeless is a critical first order right that ensures that a whole host of embodied acts, including the most basic and intimate, are able to be performed at all. So one of the conference goals then, one of the goals of the book, is to both unpack the ways in the many ways in which marginalized groups are subject to disproportionate surveillance, but also the disparate harm suffered by these groups when subject to a privacy violation. Privacy violations are, for marginalized communities, often a matter of life and death, not just a matter of dignity or autonomy, as privacy has often been framed. The harms are not intangible. They are material, they are concrete, and they are visceral. Moreover, privacy law, far from protecting the privacy of the marginalized, is structured in such a way to ensure that marginalized folks lack legal privacy rights. And here's one example. So the so-called secrecy paradigm, a term coined by privacy scholar Daniel Soloff, exists in both the constitutional and private tort law context. And it provides that once information is exposed, even marginally, even in a limited context, legal protections over that information evaporates. And what that means that for many marginalized groups, for example, those that are living their lives on the streets or in densely populated housing complexes, they may lack the physical barriers needed to create privacy. They may lack the financial ability to purchase expensive tech barriers, a better phone, for example. And this lack of lived privacy creates a feedback loop preventing legal privacy and a feedback loop of privacy loss. As explained by one of our esteemed colleagues, Professor Chiara Bridges, wealth is in many ways the condition of possibility for privacy. But beyond privacy harms and the law's role in facilitating those harms, we'll also be discussing how members of marginalized groups, again, no newcomers to concerns about privacy, have been fighting back, resisting surveillance, resisting conformity, resisting violence, notwithstanding that the decks have been stacked against them. Whether it be through wearing physical masks and hoods, using online encryption technology, or refusing to have their gender policed through restrictive gender marker and identification policies, bathroom bills, and the likes. Marginalized groups have for a long time signaled and communicated resistance to surveillance regimes through their functional efforts to maintain privacy, even if those functional efforts are imperfect and don't lead to perfect privacy. Put differently, people are not sitting idly by, being acted upon as docile bodies of the state and corporate surveillance regimes, but have claimed their agency and fought back. I believe, and hope we'll discuss, that American society and law reform has a lot to learn about why privacy matters and how privacy law can be restructured from these acts of resistance. And I look forward to discussing that throughout the day. by understanding acts of privacy maintenance as both acts of symbolic and material resistance to racist, xenophobic, and transphobic surveillance regimes, privacy may be able to transform, promote relatively weak individualistic right to an anti-subordination legal tool, potentially entitled to protection under the First Amendment's robust safeguards for expressive conduct and related equality provisions. Put differently, the state understands that when people engage in efforts to protect their privacy, often undertaken by marginalized groups, that they are signaling resistance, okay, to the surveillance regime and being targeted for that. And that kind of targeting under First Amendment doctrine is, in my impermissible. You cannot target people for their speech. And I think understanding privacy as a form of resistance potentially has both doctrinal payoffs and discursive payoffs in how we think about privacy, because it transforms privacy from being an inward-looking right, an individualistic right, to an outward-facing right that's embarked on by many marginalized groups as a tool of symbolic resistance and as a tool to reclaim public space for their communities. And so I look forward to discussing these topics and others as the day goes on. Again, we have just a fantastic group of folks lined up. And one substantive programming note, and then one reiterating one of Vanessa's procedural items before I turn it over to my tremendous colleague and immigration law professor here at Colorado Law School, Professor Ming-Soo Chen, to introduce and moderate the First Amendment, or the first panel. On a substantive programming level, you'll note that the panels, and if you look at the book, the book as well, at times use different demographic factors as a means of underscoring some of the unique harms faced by members of certain communities. Make no mistake, that is an imperfect way of viewing people and an imperfect way of viewing surveillance harms. As anti-racist and feminist scholar Bell Hooks underscored, people may be subject to, quote, interlocking systems of domination, sexism, homophobia, racism, all at once. And despite the somewhat siloed panel organization, which I'm partially responsible, make no mistake that these panels and the groups they are in conversation with are deep related and deeply in conversation with each other. Regarding procedure, each panel will start with moderated questions, but the panels and the lunchtime lecture by the incredible Dr. Anita Allen from the University of Pennsylvania Law School will conclude with 15 minutes of audience Q&A. So please use the Q&A function in Zoom, not the chat function, to get your question to the moderator. And as Vanessa explained, you can upvote questions that you are dying to have asked. And so with that, I will turn it over to my colleague, Professor Chen. Thank you so much, Ming, for helping shepherd and craft this initial discussion on racial and immigrant disparities in privacy law.